Police handcuffing. Recent Irish case law on police powers to handcuff a suspect on arrest seems to prioritize police convenience over personal rights to bodily integrity and dignity. Handcuffing a person on arrest might be perceived popularly as a regular, and even unremarkable, aspect of police practice. It signifies the reality that the person has been deprived of his or her liberty, and it prevents him from contesting that reality through violence or flight. Equally, however, handcuffing is a humiliating and degrading experience for the handcuffed person, especially when paraded in public view. It must be questioned, therefore, whether the practice is necessary or even lawful in situations where the arrested person is cooperating voluntarily with the police and does not present any objective risk of violence or flight. Police handcuffing is not directly regulated by statute in either the UK or Ireland. The legal authority for it must be found in the statutory and common law principles governing the use of force to effect an arrest. The basic proposition is that a police officer, when effecting a lawful arrest, can use no more force than is reasonably necessary in the circumstances that the officer genuinely believes to exist at the time. Critically, the officer is treated on the basis of the circumstances he or she genuinely believed to exist, e.g. a real risk of flight, even if the officer was mistaken about those circumstances. Nevertheless, the amount of force used by the officer will be assessed against what is reasonable, an objective standard, in the circumstances that the officer genuinely believed to exist, a subjective standard. It is not simply a matter of what force the officer in question genuinely believed to be necessary, a subjective standard. In those until recently, there has been surprisingly scant judicial authority in the UK and Ireland on the application of these principles specifically to police handcuffing. In the UK, the primary guidance is still little more than a trial judge's direction to the jury in the 19th century case of Lee v. Cole, 1853. Interestingly, there has been a sudden burst of interest in the subject in Ireland, with no less than 2 Supreme Court judgments in the past 4 years. The latest of these was handed down a few weeks ago in the combined cases of DPP v. Pyers, DPP v. Corrigan, DPP v. Gannon, 2018, ISC 51. For the most part, however, this decision followed the Supreme Court's own previous decision in the first case, DPP, Moyles v. Cullen, 2014, ISC 7.